A murderer confessed. The DNA matched. The weapon had his fingerprints. And the jury never saw any of it. One rookie officer forgot to initial an evidence bag. That single missing signature set a killer free. Every piece of evidence in a criminal trial must travel through a documented chain. From the moment a detective bags a bloody knife at a crime scene to the second a prosecutor presents it to a jury, every hand that touches that evidence must sign for it. Every transfer must be logged. Every storage location recorded. This is the chain of custody, and it exists for one reason, to prove that evidence has not been tampered with. But here is the problem nobody wants to talk about. This chain breaks more often than you would ever believe. And when it does, killers walk. The question is not if this has happened. The question is how many times. Let me show you how this plays out in real courtrooms. A woman is found dead in her apartment. Police collect DNA from under her fingernails. They find a suspect. The DNA matches. Case closed, right? Not even close. The defense attorney requests the evidence logs. And there it is. A 4-hour gap. The evidence sat in a detective's car while he grabbed dinner. No documentation. No temperature control. The defense argues contamination. The judge agrees. That DNA evidence gets thrown out. Now think about this. The killer's DNA was literally under the victim's fingernails. She fought back. She scratched him. And none of that mattered because someone wanted a cheeseburger. If this makes you angry, wait until you hear what happened next. Now let me shift your perspective for a moment. Imagine you are a homicide detective. You have been working a triple murder for 18 hours straight. Your eyes burn. Your hands shake from caffeine. You finally find the murder weapon buried in the suspect's backyard. This is the moment that will put a killer away for life. But in your exhaustion, you hand the evidence bag to a uniformed officer and tell him to take it to the lab. You do not get his name. He does not sign the log. You assume someone else will handle it. 3 years later, at trial, the defense asks one simple question. Who transported this weapon between 2:15 and 4:45 p.m. on October 14? Nobody can answer. The weapon is inadmissible. And you just learned the most expensive lesson of your career. Here is where this gets personal. These are not just legal technicalities. These are your neighbors. Your co-workers. People walking past your children's school. When chain of custody failures release dangerous criminals, they go somewhere. They do not disappear. They move into apartments and houses and communities. Law enforcement officials estimate that hundreds of violent criminals have been released over the past 2 decades due to evidence handling failures. But that is not even the worst part. Many departments still use paper logs. Handwritten entries that can be smudged, lost, or simply never completed. In an age of digital tracking and blockchain technology, we are trusting murder evidence to systems designed in the 1960s. And prosecutors are losing cases because of it. But that is not even the real scandal. Pay close attention, because what I am about to tell you changes everything you think you know about criminal justice. Defense attorneys do not accidentally discover these chain of custody gaps. They hunt for them. There are law firms that specialize exclusively in chain of custody challenges. They have investigators whose only job is to find the one missing signature, the one undocumented transfer, the one moment of human error. And here is what keeps prosecutors awake at night. These attorneys are getting better. Faster. More sophisticated. They are building databases of which departments make the most mistakes. Which officers forget to sign. Which evidence rooms have security gaps. This is not about finding the truth anymore. This is warfare. And the evidence is losing. Now you need to understand exactly how these cases fall apart. There are 3 critical vulnerability points where chain of custody typically breaks. First, the handoff between crime scene and transport. Officers are focused on securing the scene, not paperwork. Second, the evidence room intake. Overworked clerks processing dozens of items per hour make mistakes. Third, the laboratory transfer. When evidence moves between facilities for testing, documentation gaps appear. But here is what defense attorneys know that juries do not. It only takes one gap. One moment of doubt. One question that cannot be answered. When a defense attorney stands before 12 jurors and asks how can you be certain this evidence was not tampered with, and nobody can prove it was not, reasonable doubt is born. And reasonable doubt sets killers free. Let me tell you about the case that changed everything. 1995. A double murder trial in Los Angeles. The prosecution had DNA evidence, blood evidence, and a timeline that pointed directly at the defendant. They had witnesses. They had motive. They had what should have been an unbeatable case. But the defense did something revolutionary. They did not try to prove their client was innocent. They proved the evidence was untrustworthy. They showed that blood samples sat unrefrigerated for hours. They demonstrated that evidence bags were carried improperly. They revealed that the timeline of collection was impossible to verify. The jury acquitted. And every defense attorney in America took notes. This was not about innocence. This was a masterclass in destroying chain of custody. And it worked perfectly. The legal system has never been the same. So where does this leave us? Some departments are finally implementing digital tracking systems. Barcodes on every evidence bag. GPS logs of every transfer. Automated temperature monitoring. Blockchain verified documentation that cannot be altered. But these reforms cost money. And most police departments cannot afford them. Meanwhile, defense attorneys continue refining their strategies. They are getting better at finding gaps. Better at creating doubt. Better at setting guilty people free. The chain of custody was designed to protect the innocent from planted evidence. But it has become a weapon that protects the guilty from justice. And until every department in America modernizes their evidence handling, killers will continue walking out of courtrooms. The question is whether your community will be the next one to learn this lesson the hard way. Now you know how one broken link can set a murderer free.